And we are here for Board of Township Trustees for Eaton Township et al. Versus the Village of Grafton. And those cases 19CA011555 and 011559. Each side will have 15 minutes to present its arguments. Mr. Schrader will be arguing the entire appellant's case. Mr. Schrader, if you wish to reserve up to 5 minutes for rebuttal, you may do
I do.
so.
Thank you.
You want the full 5 minutes?
Yes, please.
All right. All right, and I'll do my best to keep track of the clock for everyone here. All right, we have read your briefs and we're ready to begin when you are.
Okay, great. Thank you. We're here on a declaratory judgment matter, which means the standard of review is de novo. It's a matter of law, basically interpretation of what a judgment entry entered in 1988 means with regard to Section 4 of that entry, which talked, as a bit of background, back in '88, the state of Ohio wanted to build a prison and wanted to annex in Grafton in order to do that. The trustees opposed that. Judge Joseph Sirigliano was the trial court judge at the time, worked his tail off actually to get this thing settled. When you look at it, he came up with settlements that were signed by people that weren't even part of the lawsuit. The state of Ohio, for example, agreed to use fire services from the townships. The village separately agreed that they would provide water, sewer, well, sewer at least, without annexation. And it was amazing how this thing was put together before there were any statutes that allowed for annexation agreements as exist today. What brings us here is that the township takes the position, both townships take the position that Section 4, which carved out a 100-foot wide strip all along the perimeter of the annexation, amounted to a barrier for future annexations. The village takes the position that that's just a boundary and it doesn't mean anything more than that. Everything else we filed, the injunctive relief, that type of thing, all of it depends on the declaratory judgment. To be quite frank, if ultimately the court, hopefully after hearing some evidence, decides we're right, we get to that stage and hopefully we get an injunction. If the court decides our interpretation is wrong, we're done. So let me tell you why we think that section means what it does.
Attorney Schaefer, this is Judge Carr. I'm sorry, but I have a question for you before you go any further.
Sure.
In regard to the causes of action that are pending before the court below, I know you had the declaratory judgment and obviously you had the injunctive relief, but was there a contempt of court as well? Yes,
we had included that for fear that if we didn't, we might have been prohibited from ultimately doing it. Frankly, I never wanted to find anybody in contempt. I figured if I got the declaratory judgment, people would catch on, everybody do what's right, and would be going home. But I felt like I had to include that. So no offense.
Well, the only reason I'm asking that is if it was a contempt, there was a contempt of court pending as well. I'm just wondering if there may be different evidentiary standards and as to what you could look at and so forth. I'm just throwing it out. I don't know.
If we'd have gotten to that stage, there might have been. We never made it. We never got past the declaratory judgment part. That is, what does that section of that consent judgment entry mean? So that's why we.
So the court never heard the contempt of court.
That's correct, and never really heard the injunction either. We were talking about the declaratory judgment. It's all based on, as I said, what does that language mean? A couple things that we need to talk about as practicalities. The first of which is, in annexation then as now, you can only annex if you're contiguous. That's why that 100-foot strip is important. Then as now, public officials, if they're going to enter into a consent entry and allow 1,750 acres to be annexed, probably want something in return. That's the nature of the consent judgment entry. What the townships got at that point was that 100-foot strip, which they believed by law acted as a barrier to further annexation. If all it was supposed to be is a boundary, that's a line on a piece of paper. That's a line on a map. That's a welcome to Akron sign. That's all they needed. They didn't need a 100-foot strip. They didn't need to have the township pay half of the cost of the legal description of the map to come up with the description and map of this 100-foot wide strip all around the perimeter. Never in my experience, and I've done a lot of annexation along the last 42 years, has a township ever helped pay for the legal description for an annexation to take land away from their communities. So there had to be a reason for that 100-foot strip, and we're saying that the reason is that it's a boundary that is a barrier to annexation, not just the normal everyday boundary between a township and a city. We wanted to have some witnesses, folks that were actually trustees back then, possibly even Judge Sirigliano. There was a motion in limine granted. We never got to that. We think those witnesses should have been heard on the issue of how you interpret that consent judgment entry. And that's the only thing we wanted them to testify on. There was never an argument ever that there was some side oral agreement. Doesn't need to be. If you're not contiguous, you can't annex. And the 100-foot strip prevented them from being contiguous. That's why all this, what's where we think the court perhaps missed the boat because it bought the notion that there should not be parole evidence to support an oral contract. We never argued there was. We wanted parole evidence, and we've cited cases that say that's permitted, to describe the intent of the parties and coming up with that language. That's what the evidentiary effort was for. We were limited at the trial court to, okay, tell me why this makes sense within the four corners of the agreement. And frankly, I think we did that well enough that it should have been granted. Clearly, there was a reason for that to be a 100-foot wide strip. It wasn't 25, it wasn't a line on a map, it was a 100-foot wide strip all along the area of annexation.
I know it's hard because I'm only talking, via telephone, and you can't see me. But I'm just trying to figure this out as well. And I'm thinking the 100-foot wide strip also could have easily been put in the consent decree to prevent further annexation.
It could have been.
As it's not contiguous.
It could have been, but it didn't need to because the law always requires there be contiguity. The other reason I suspect it was never put in there, and we'd have had to have some testimony to establish this, which isn't in the record because we weren't allowed to have witnesses, is that, these are public officials. And I spent a little part of my life doing that too. I was 28 years a trustee and about a year and a half on county council. There's a lot of times when government officials are willing to do stuff, but they're not willing to call it that. I'll give you an example, this COVID-19 stuff. Generally, I also have a bachelor's in political science. The core definition of socialism is you give public money to private entities. In this crisis, we gave money to businesses, we gave stimulus checks to people. That's pretty much the definition of socialism. Nobody's calling it that, of course. And everybody, both parties agreed and voted to do all that. They might not have if they were calling it socialism. So in the political realm, it's not unusual to be hesitant to label something because it causes problems with your constituents. I suspect that's what happened here in terms of why they didn't make it more specific. But I agree with you, Judge Carr, they could have made it more specific. And had they, I guess we wouldn't be here, and I would have not had the argument that it's ambiguous. But in my view, it's very ambiguous. Why otherwise do you have this 100-foot strip? Why is it required to be around the entire perimeter of the annexed area? Why does it exclude what was already the border before? It only makes sense as being a barrier to annexation. In addition to that, you have the other parts of the agreement, some of them contracts as appendices to the consent judgment entry, some of them in the consent judgment entry itself, that talk about things like the village agreeing to provide sewer or water without annexation. Why do that if you expect it to allow the annexation to happen? Why does the township agree to this 100-foot barrier, even help pay for the legal description and map, if the very next day the city could have theoretically, after the next day after this annexation is allowed, go out and annex it? That would have made no sense. It would have made no sense to have agreements about providing water or sewer without annexation. Interestingly, both the court and opposing counsel make a big deal about the notion that in some of those documents, it includes language about that being an agreement in perpetuity, and says that since there's nothing in Section 4 that says that, you can do whatever you want as far as annexation.
Mr. Schrader, you're
Yes.
right at your 5 minutes. You're welcome to keep going. I just wanted to let you know where you were.
I'll just conclude this part. The fact is that it doesn't need to be said in a consent judgment entry that's effective in perpetuity, because every court order is effective in perpetuity once it's journalized, until and unless a court amends it. With that, I'm going to reserve whatever's left. Thank you.
Okay. All right, Ms. Holderman, whenever you're ready. Oh, you have to unmute. There you go.
Okay, can you hear me? I'm sorry.
Yep, sure can, no problem.
Not used to it yet. May it please the court, Gretchen Holderman on behalf of the appellees. In the instant case, the appellates have brought this case without standing legal authority or any viable claims which would not otherwise violate the statute of frauds. They have improperly recommenced the within litigation in an effort to prohibit the village of Grafton from annexing property it recently purchased. They've done so while claiming to rely upon the 1988 consent decree, which was involving a very different annexation petition that had been filed by the state of Ohio. And that petition was filed pursuant to a different statute. Appellees submit that appellants' claims have no foundation. And in fact, the village recently purchased these properties in 2018 and 2019 and sought annexation, importantly, under revised code 70916B. And I would note that in 2001, the legislature enacted that statute, which effectively provides that there is no standing, no right, no argument or opportunity to be heard in the event that a municipality makes an effort to annex contiguous property which it owns. And so I would submit that this entire case is filed without standing on behalf of the appellants. They have no opportunity to
Counsel.
Yes.
Counsel, this is Judge Carr. Since Attorney Schrader did his political analogy, I'm going to use a similar one with everybody uses the phrase, isn't that the tail wagging the dog, when they're talking about people talking around in circles, and especially in political circles. The argument you just made, isn't that the tail wagging the dog? Because the whole point is it's not going to be contiguous unless you include that 100-foot property.
I understand, Your Honor, and I would submit that beyond the application of 70916, what the trial court relied on here is actually the unambiguity of the 1988 consent decree. So notwithstanding my separate argument that there's a distinction in these separate annexations, I would submit that the trial court looked at the 1988 consent decree, determined that there was no reason to reach in any further analysis because the consent decree itself was clear, and that section 4E in the consent decree, unlike Mr. Schrader's argument, was there to simply take out a portion of the property. The parties certainly contemplated future annexations, and as the trial court determined, could have said that there would be no future annexation, and could have said that this barrier, this 100-foot strip, would exist in perpetuity like it did relative to the provisions in the agreement pertaining to the village of Grafton providing sewer opportunities and the state of Ohio providing protection services opportunities. So I hope that answers your question, Your Honor.
It answers my question, but it raises more questions, and that is in regard to the court. You said the court found that it was not ambiguous and it was very clear, but yet it seems like the court is interpreting it itself as to what it means.
The trial court stated that it was the trial court's duty to interpret its own consent decree. Am I misunderstanding what you're
Well,
saying?
it's a matter of, you said that it's not ambiguous. The trial court said it's not ambiguous. But yet it doesn't really say in there one way or the other what it's for, right?
Oh, okay. Well, I would submit that that particular issue was a matter of negotiation between the parties, just like reducing an award or a claim for damages. This was effectively a settlement agreement, and the parties agreed along the way what they would and they would not agree to in order to end this litigation. So my point about it not being ambiguous, and I think that the trial court's point was there was no reason to look further other than the plain statement that the original annexation petition and the amount of property that was encompassed therein would be reduced by a certain strip of land. And that was agreed to by the state of Ohio. And there was no notice to any future purchasers that there was any kind of alienation of land, which we briefed, as you know, Your Honor, in our brief extensively, that you cannot have an alienation of land or any kind of non-written encumbrance without violating the statute of frauds. So it was upon that basis that the trial court would not allow the evidence, which as presented was the sum total of Mr. Walker's affidavit just stating that that's not what was intended, and Mr. Moncheen's affidavit, which just said kind of a blanket, we would be harmed. You know, of course, there's kind of a strange competing relationship between municipalities and townships relative to annexation, but that's why I think that the enactment of 70916 is important, to realize that that statute would help to make clear these kinds of annexations and who would have standing and who would not to challenge them. I would submit, Your Honors, that the parties might have wanted that when they went into it, but they certainly didn't agree to that and had every opportunity to do so. The court below found that, you know, allowing evidence in an effort to change or modify a written document would kind of open up a can of worms. And I think he mentioned, you know, are we going to ask every court what was going on in their head when they helped fashion or carve out a settlement agreement by the parties? The court clearly determined that what the appellants are claiming was not memorialized in that 1988 consent decree. And I would submit that that vehicle using the 1988 consent decree would have been the only possible means or method for the townships to challenge this annexation, which they did, and that the court thoroughly took oral argument, took extensive briefing, and understood what the parties were claiming when it decided that no evidence that wouldn't violate the statute of frauds would be permitted under the circumstances. I would further note for your honors that, I'm sorry.
Counsel, I'm sorry. I'm going to ask you the same question I ask opposing counsel, and that is in regard to the actual procedure. So the court did say it's the motion for declaratory judgment for temporary restraining order, et cetera, and to find the village of Grafton in contempt of court. But it seems like, and I know one argument could be the court, by ruling on the declaratory judgment, found there is no violation of contempt of court. But it just seems like those are a little different standards. So would you address that issue?
Yes, Your Honor. I think that they probably would be different standards, especially if you're talking about direct or indirect contempt. I think that you'd have to look further into the involvement of the parties. As Mr. Schrader mentioned, the annexing entity was the state of Ohio. It was not the village of Grafton. The village did not own property at the time. So I think that it would be a different analysis, but I think you would still have to go to the heart of what the agreement required as a court order to then determine if the parties had indirectly or directly committed an act of contempt. We didn't get to that, but I think that the court certainly understood what the evidence would have been if we had gotten to that. And I think, like you had mentioned, Judge, that indirectly the court denied that, but didn't really do the analysis. So yes, I agree the analysis would be different, but I still think that it would ultimately go to the heart of the agreement and what was required and contemplated by the parties when they entered into this consent decree, which was a court order. Hope that answers your question.
Thank you.
I would mention to your honors that the stay that was initially granted in this court, I think was granted erroneously. I believe the trial court recognized that. And I would note that now, a year later, the village of Grafton is still yet being prohibited from annexing its property. I would ask the court not only to affirm the trial court's ruling below, but I would also ask the court to lift the current stay so Grafton can go forward. It is in fact the case that Grafton has a lot of economic development plans, which includes this 100-foot strip of property. I think that it's interesting that there was the request for injunctive relief, because I feel that that allowed the parties to at least tell the court what their harms and what their claims were. And having gone through the Rule 65 standard, the court did not abuse its discretion in denying relief, had every opportunity to look at the evidence, and certainly it lifted its stay, and I think that this stay should also be lifted so we can go forward and do exactly what we have a right to do as a village. I would submit that the harm to the village by the litigation is real and continuing now for a year. So respectfully, I would ask the court to please lift the stay, affirm the trial court, and determine that there was no abuse of discretion. Whether or not you look at the entire case de novo, I think you'll find that the court was thorough and looked at all of the issues. And if you have any other questions, I'd be happy to answer them.
Are there any questions?
No, thank you.
All right. Mr. Schrader, you have about 4.5 minutes.
Hopefully I won't need to take them. As to standing, first off, Grafton Township and Eaton Township were original parties to the 1988 judgment entry that's the core of this case. How could we not have standing? Number two, I don't believe the standing issue was raised below, so they can't raise it up here. I think that handles the standing argument. The argument about this being a restraint on property that nobody got notice of similarly can be resolved pretty easily. Number one, the consent judgment entry was recorded at the clerk of court's office, so that's notice to the public of that entry. Number two, even the consent judgment entry itself was also recorded at the county recorder's office, which is generally considered to be notice to everybody. And number three, guess what? The village of Grafton was a party to the original lawsuit. So it's not like somebody doesn't know what's going on here, or there's somehow no notice. There's all the notice you could possibly give. The issue is, what does that consent judgment entry mean? Now, there's some legal policy value, I believe, in upholding and giving effect to the provisions of a consent judgment entry. So that's what we're trying to do. If it means what we say it does, then there's been no contiguity for the last 32 years. That may be in part why there've been no annexations there for the last 32 years. There has to be some reason for that language to exist. The other thing is, we keep talking about oral contracts and parole evidence. The briefs are pretty clear. For virtually every court of appeals in the state that's looked at this has said that you can, in fact, allow and should allow witnesses, not on an issue of an oral argument, but rather on what was the intent of the parties at the time they entered into the consent judgment entry. That's why I proffered the two witnesses, and had there not been a motion in limine, I would have brought in a third, Judge Sirigliano. Now, interestingly, during the trial court argument, the trial court said, well, you know, he's sharp as a tack, which is true. I talked to him. He's an excellent judge, used to be on the Court of Appeals. And frankly, I disagreed with the court, but I've learned over the years to keep my mouth shut and not start additional arguments that I don't need to. But I would have done precisely what the trial court said you shouldn't do. I wouldn't have called him up. I don't think that's ethical or proper for a judge to do. But I would have subpoenaed him. I know he didn't want to show up and start telling his successor what to do. So it would have been very diplomatic. Subpoena him, ask him the questions very carefully. That way we'd know one way or the other. And probably the best witness would be Judge Sirigliano, because I know he worked his tail off to get this done. I mean, when you think about it, that was an amazing case. The village benefited from getting that 1,750 acres annexed. They got their prison. They got their income tax from the prison. All the township wanted and all the township got was a barrier to annexation for the future. That was the reason for the 100-foot strip. And if you don't consider that to be the reason for the 100-foot strip, then it makes no sense for that language to be in there at all. Why would any fairly sophisticated local official, and Ernie Walker and Mr. Kovacic were trustees from each of the townships at the time, were fairly sophisticated public officials. They had to get something in exchange for that. That's what they got, was a 100-foot barrier, and it worked for 32 years. Unless you have any other questions, that's.
Anyone else?
Yes.
No, thank you.
You good? Your timing is perfect.
Thank you.
All right. Thank you all for your arguments. We will take the matter under advisement. We will issue our written decision in due course. It'll be mailed to all sides, as well as posted on our website and on the Supreme Court website. Everybody have a great day and stay safe.